Hi friends, this is CMA Deepika Bhugra Prasad, an insolvency professional. Ever since its inception, IBC has been a great learning experience for us all. So I just thought of creating a snippet series in IBC. So friends, welcome to Insolvency Insights, an illuminating snippet series curated by me. Join me as we delve into pivotal judgments under the Insolvency and Bankruptcy Code to navigate the complexities of insolvency proceedings and key judgments having an impact on IBC code. So I'll just share one such judgment today. So this is the case of Greater Noida Industrial Development Authority versus Prabhjit Singh Soni. So the case titled Greater Noida Industrial Development Authority versus Prabhjit Singh Soni and another dealt with the rejection of a claim submitted by a claimant solely based on its form. The Supreme Court in GNIDA versus Prabhjit Singh Soni has held that NCLT has inherent power to recall an order. The Supreme Court also held that the form prescribed under code to submit claims is directory in nature, and what is necessary is that the claim should be supported by proof. Now, what is the factual background of the case? The GNIDA, being a statutory authority, acquired land for setting up an urban and industrial township. On 28th of October 2010, one of the plot of the land acquired by it was allotted to JNC Construction Limited, CD, by way of lease for 90 years, charging premium which was payable in installments. The dispute originated from the default of payment by Messrs. GNC Construction Private Limited, the corporator, to the appellant GNIDA, and following this default, the initiation of CIRP ensued against the corporator, wide order dated 30th of May 2019. Now, GNA filed a claim of rupees 43.40 crores in the category of financial creditor. However, the resolution plan proposed to pay only a fraction of this amount, that is only rupees 1.35 crores, categorizing GNIDA as an operational creditor. The RP treated GNIDA as an operational creditor and requested to file claim in category of operational creditor. The GNIDA did not file fresh claim, and in the meantime, the resolution plan was approved by NCLT on 4th of August 2020. The GNIDA filed an application against its treatment as operational creditor and an IA for recall of order, approving the resolution plan. NCLT rejected the applications of GNIDA, and appeal filed before the NCLAT was also rejected. And then an appeal was preferred to Honorable Supreme Court. Now, what were the findings of the Honorable Supreme Court? The Supreme Court observed that a court or a tribunal has inherent power to recall an order to secure ends of justice or to prevent abuse of the process of court. IBC or regulations framed thereunder do not prohibit exercise of such inherent power. Section 60, subsection 5C of the IBC empowers NCLT to entertain or dispose of any questions of priorities or any question of law or facts arising out of or in relation to the insolvency resolution or liquidation proceedings of the CD or corporate person under IBC. Rule 11 of NCLT rules preserves the inherent power of the tribunal. The Supreme Court observed that even without empowering provision, a tribunal has the power to recall. Power to recall has to be used sparingly on limited grounds, that is, where an order is without jurisdiction, or a party has not been served notice with, or an order has been received on misrepresentation of facts or plain fraud on the court. The Honorable Supreme Court further held that the application filed by the GNIDA for recall was maintainable as it was not informed about the meeting of the COC, and the proceeding was ex parte. There was misrepresentation on the part of the RP, and the NCLT erred in approving the resolution plan. The Supreme Court held that the resolution plan did not meet the requirements of Section 30, subsection 2 of IBC, read with Regulations 37 and 38 of CIRP Regulations 2016. It was undisputed fact that the claim of rupees 43.40 crores has been filed. GNIDA was advised to file claim in Form B in the category of operational creditor rather than in Form C meant for financial creditors. Assuming that GNIDA did not heed the advice, once the claim has been filed with proof, the same could not have been overlooked. and the form in which a claim has to be submitted is directory. What is necessary is that the claim should have support with proof. Resolution plan has not only failed in acknowledging the claim, but also in mentioning the correct figure of the amount due and payable. The resolution plan mentions the figure at rupees 13.47 crores, whereas according to GNIDA, the amount due was rupees 43.40 crores. These aspects have not been considered by NCLT and NCLAT. The resolution plan also did not put GNIDA in the category of secured creditors, although by virtue of Section 13A of 1976 Act, a charge was created in favor of GNIDA. Non-placement of secured creditor in the category of secured creditor has affected adversely the interests of GNIDA. Regulation 38.3 of CIRP Regulations 2016 provides that the resolution plan should demonstrate that it is feasible and viable and that it has provisions for approvals required. When land of the corporate debtor belongs to a statutory body, a closer examination of resolution plans' feasibility has to be undertaken. This aspect was also not deliberated by NCLT or NCLAT. The appeal was allowed and the Honorable Supreme Court sent back the resolution plan to COC for resubmission after satisfying the parameters provided under the code. So this is what I thought of sharing in a small way, in small time, in little time, as we all are very busy in these days. So I thank you all, and this is Deepika B. Prasad signing off, and we'll catch you with the next case. Thank you.